Welcome to the K&L Gates Working Wise podcast series. My name is Mark Filipini. I'm a partner resident in Seattle and a member of the firm's labor, employment, and workplace safety practice area. In this podcast, I will discuss recent transitions at the National Labor Relations Board, which I'll refer to as the NLRB or the board under President Trump, significant board decisions issued late last year, and finally, what we should expect from the NLRB in 2018. I'll begin with a brief overview of the NLRB. The board is a federal agency with primary jurisdiction to interpret and enforce the National Labor Relations Act, which governs almost all private sector labor management relations in the United States. The board itself, which sits at the top of the agency in an appellate capacity, has 5 members appointed by the President and requiring the consent of the Senate. The NLRB also has 26 regional offices spread around the country under the direction of its general counsel, who also must be appointed by the President and confirmed by the Senate. The NLRB has long had an unwritten tradition that 3 of its 5 members identify with the party that controls the White House. While all 5 board members have a theoretical duty to be neutral, in reality, we see more pro-employer decisions during Republican presidential administrations and more pro-union decisions under Democratic presidents. This dynamic means that NLRB precedent is often susceptible to revision when the White House changes hands, and the second half of 2017 was no exception. By the end of the summer, the Senate confirmed 2 of President Trump's GOP appointees. Together with a holdover GOP member from President Obama's administration, Republicans held a 3-2 majority on the board for the first time since 2007. President Trump's choice for general counsel, who holds considerable discretion to decide what cases the board hears, was sworn in shortly thereafter. While the stage was set for change, the Republican majority knew that it needed to act quickly, as the holdover GOP member announced he would retire at the end of 2017. The board did just that, issuing a number of important decisions starting in mid-December that overturned recent precedent and gave us a preview of what to expect once the NLRB is back to a Republican majority at some point in 2018. I'll focus now on 4 decisions that emerged from the flurry of December NLRB activity. The first 3 were low-hanging fruit, as the board overturned cases decided within the last few years that had drawn considerable negative reactions from employers and their allies. In high-brand industrial contractors, the board overturned a controversial Obama-era board ruling that had expanded joint employer liability. For many years, the board determined joint employment status by assessing whether each alleged employer exerted direct and significant control over employees regarding essential terms and conditions of employment, such as hiring, discipline, supervision, and termination. But in Browning-Ferris Industries, the NLRB significantly broadened the joint employer standard. The test would no longer be what actually happened in the workplace, but rather whether the alleged joint employer had the potential to control aspects of the workplace, either directly or indirectly, even if it had never actually exercised such authority. The high-brand decision returns us to the prior standard, meaning that the NLRB will once again require proof that the alleged joint employer actually exercises direct and immediate control over the essential terms and conditions of employment of the employees in question. And while not directly addressing the issue yet, the ruling also signals that the NLRB may soon reverse course on whether franchisors are joint employers with their franchisees. The second case I'll mention from December 2017 is PCC Structurals. In that case, the board ended its recent endorsement of micro-units for union organizing drives. On that issue, PCC Structurals overturned Specialty Healthcare, a 2011 NLRB decision that granted unions unprecedented power to determine what constitutes an appropriate bargaining unit of employees for organizing purposes. By filing an election petition, a union has the first opportunity to define the group of employees it seeks to represent. The employer has the right to challenge where the union has drawn the lines, including whether the group should be expanded to include other employees sharing a similar community of interest. A traditional purpose of this exercise is to ensure that workplaces are not composed of many different small bargaining units, each potentially represented by different unions seeking different terms and conditions of employment. Specialty healthcare required an employer to demonstrate that the petition for a bargaining unit was, quote, truly inappropriate, and that the employees it wished to add shared an overwhelming community of interest with the union's preferred group. By flipping the script, specialty healthcare led to an influx of smaller bargaining units, which in turn made it easier for unions to organize workplaces where they only had support among a minority of employees. PCC Structural erased this much-derided concept of microunits and reinstated the traditional community of interest test for determining an appropriate bargaining unit. This test considers factors such as functional integration, employee skill and interchangeability, working conditions, wages and benefits, common supervision, and bargaining history to determine whether a proposed unit of worker shares a community of interest. While the NLRB has changed its view of microunits, we want to caution that every federal appellate court, except for the First and Ninth Circuits, have already upheld the specialty healthcare standard on appeal in multiple contexts, and it is not clear what the federal appellate courts will do in future cases when presented with the microunit decision. The third case of interest is Raytheon Network-centric system, where the board returned to the long-standing rule that there is no duty to bargain over changes made pursuant to a past practice. In Raytheon, the parties had a collective bargaining agreement that incorporated the right to change benefit plans and costs. During a contract hiatus period, the employer made unilateral changes to health benefit plans and costs, just as it had done in the past. Although it was following established past practice, under the 2016 NLRB decision in DuPont, the employer would have had a duty to bargain before making these changes. However, the new NLRB applied the pre-DuPont standard to the case, holding that the employer did not need to bargain the modifications to health care benefits after contract expiration because it had made similar changes every year for the last 12 years. Finally, the last case I'll mention may not have received the most press, but it has the potential to be the most far-reaching of the Trump NLRB decisions thus far. In Boeing Company, the board reversed its 2004 decision in Lutheran Heritage, which the NLRB had used in recent years to condemn a wide variety of facially valid workplace rules, policies, and handbook provisions. In Lutheran Heritage, the Bush-era NLRB held that a facially valid workplace rule could nevertheless violate the National Labor Relations Act if an employee would reasonably construe the language of a work rule to prohibit the exercise of labor law rights. If it did, then the rule, regardless of whether it actually restricted any protected activity, was unlawful. The Obama NLRB aggressively interpreted and expanded the Lutheran Heritage holding to the point of directing its regional offices to comb through employer handbooks obtained in unrelated cases to see if anything might run afoul of the very low bar it set for reasonably chilling employee rights. In the Boeing decision, in order to provide greater clarity and certainty to all parties, the board indicated it would henceforth categorize workplace rules as falling into one of three categories. The first category is for presumptively lawful rules, which either do not prohibit or interfere with employee rights when reasonably interpreted, or the potential adverse impact on protected rights is outweighed by justifications for the rule. An example of this type of rule was a no-camera requirement in the Boeing case, where the employer supported its rule with multiple business and security justifications. The board also found that a rule requiring employees to have harmonious interactions and relationships in the workplace, and other rules requiring employees to abide by basic standards of civility, would be categorically lawful. This is a 180-degree departure from the Obama NLRB. The second category of rules includes those warranting individual scrutiny on a case-by-case basis, while the third category is for presumptively unlawful rules that prohibit or limit protected conduct without being outweighed by legitimate business justifications. The NLRB gave a rule prohibiting discussion of wages or benefits with another employee, which has long been unlawful, as an example of a rule falling into this third unlawful category. Finally, I'd like to conclude with some predictions for 2018. Although the board is currently deadlocked at 2-2, President Trump has nominated a third Republican member who is awaiting confirmation by the Senate. Assuming that happens at some point in 2018, we predict a fresh round of attacks on Obama-era NLRB decisions in a number of areas. Those include, but are certainly not limited to, what constitutes concerted employee activity protected by the National Labor Relations Act, whether employees have a presumptive right to use their work email system to engage in union organizing and other protected concerted activities, and whether and when an employer must turn over to a union any witness statements gathered in connection with the employer's investigation of a workplace issue. We hope you enjoyed this episode of the K&L Gates Working Wise podcast series. More episodes in our series can be found at klgates.hub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thank you for joining us.